only have 17 days to do their job. And if there are 4 firms involved, then the third and fourth firm would only have 12 days. Well, again, all these are not very important for exam purposes, and also it is only a matter of practice. If you work in a law firm, all this easily follow. It's not really anything complicated. Now, of course, in relation to completion, we have to mention time is of the essence. And remember the case. This case we learned in our obligation class. Privy Council said that late for 10 minutes in completion was a breach of the time for completion, because time is of the essence. And the vendor was entitled to cancel the contract, even though the vendor would not have suffered any loss, because you make time is of the essence, you have to observe the time. And one more thing about time is of the essence, not just accept the time, but also exactly on the same day. Because under section 71, subsection 1b of Cap 1, Interpretation and General Clause Ordinances, the chapter 1 of Hong Kong laws, it is said that, if a due day in a document is a public holiday, the day following will be considered the due day. So this gives a very general provision to solve some practical problem. When people agreed to perform under a contract, they may forget that the date agreed for performance is on a public holiday. Now, if that's the case, don't worry. 71 subsection 1b will give you a way out, because the due day would become the day following, of course, the working day following. And in this particular case, Rusky and Rose Imported Limited, Chief J said that, well, if time is of the essence is inserted in the agreement, then this section 71 subsection 1b would not be applicable. You have to have completion on the day agreed in the document. So, in fact, the facts of the case is completion, again about completion, agreed to be on Sunday, and purchaser did not show up to complete, and try to rely on 71 to say, oh, I can complete on Monday, the working day. But Chief J said, no, once you have time is of the essence, that overrides the legislative provision. So failure to complete on Sunday was a breach. Now, another point that you have to remember, because, well, all this are likely to appear in exam. That's why I have to emphasize about completion. If any question asked on completion, the time for completion is usually a hot topic. Now, what about if you only said we complete on certain day without specifying the time for completion? Well, if that's the case, then we have a new rule to deal with the situation. It's called the midnight rule. That means the purchaser will be entitled to go to the vendor solicitor's firm to request for completion before 12 o'clock the next day. And in fact, this is governed by the Law Society Circular number 15/1989, where a contract of sale and purchase provides for completion to take place on a certain day without specifying the time. Time for completion will not expire until midnight. Okay, until midnight on that day. So if you want to prevent this rule from applying, it's necessary to provide specifically in the contract not only the date but also the time for completion. Well, assignment. Assignment is the document usually a deed, to transfer the right and interest of the vendor in relation to a property to the purchaser. Must be a deed if you transfer a legal estate. And in the absence of any expressed provision in the assignment, Section 16 and 17 of CPO apply. And in fact, all lawyers, more or less, would take advantage of these two sections, because these two sections make it unnecessary to spell out the interest transfer in details. Section 16 said that unless the contrary intention is expressed in the assignment, an assignment shall operate to assign with the land what right? All rights, interests, privileges, easement, or appurtenances in, over, belonging, or appertaining to that land, or at the time the assignment used, held, occupied, or enjoyed with that land, and things attached to the land. So also remember this, this fixture. Fixture would also be assigned, or permanently fastened to anything attached to the land. That is the fourth part definition for land under Section 2 of CPO. So once you have an assignment, unless you expressly said, well, I will not assign the things attached to the land to the purchaser. Otherwise, everything mentioned in Section 16 would also be assigned at the same time. And subsection 2 said, section shall not operate to give to any person a better title than that assigned, or any better title than or that enjoyed by the assigner. Of course, you cannot get anything better than the person who is holding the title before. Section 17 said, unless the contrary intention is expressed, an assignment shall operate to assign all the estate. Now we are talking about the interest of the land, estate, right and interest in the land assigned, which the assigner has. So it will include legal estate, equitable interest, etc. And 16 talks about the other interests attached to the land. Now, we just learned that formal sale and purchase agreements drafted by the vendor solicitor. The assignment was normally drafted by the purchaser solicitor. So each side would have a duty to draft a document. And of course, just like the purchaser solicitor to approve the formal agreement, the vendor solicitor have the duty to approve the assignment also. And now, if you want to look at what an assignment is like, you don't have to go to get a real assignment. Just go to Form 1 of Third Schedule to CPO. Look at it yourself. Because under Section 37, it provides that a deed, agreement, or receipt in the appropriate form given in the third schedule, this is the first schedule, shall, in regard to the form expression, be sufficient. So if you don't know how to draft an assignment, just copy. Again, the job for solicitor much easier than nowadays. Draft a formal agreement, you can adopt relevant schedule. Now assignment, you can also adopt relevant schedule under CPO. Now basically, you have this kind of contents in an assignment. First of all, you must have what we call the commencement, and always start with this word, this assignment. Now, there is no legal requirement that these words must be in capital letters, but that is the usual way the lawyer is doing in Hong Kong. So you always start the first sentence. This assignment, all in capital letter, is made or made by the assigner, blah blah blah. Now, sometime if you are a convincing lawyer, you may come across certain assignment called indenture. Remember what is the indenture? We explained that already. It refers to document indented two identical copies of deed, written on two sides of the same paper. And each party to the transaction would sign on one side and then cut into two pieces. And each party will get the part signed by the opposite party. And when these two put together, it forms a complete document. So it would make forgery difficult. Again, at common law, land is a very precious property. They don't want to allow people to forge any document to pretend them to be the owner. So they invent this kind of document called indenture. And in the old times, only parties who actually sign on the indenture could enforce that indenture. The second important part of the deed, that is the assignment, is the date. Now, remember, we say what is a deed? A deed is a document which is signed, sealed, and delivered. And the correct date for a deed is always the day of delivery. So if in the assignment is dated 1st of November 2021, that means this document was delivered to the assignee on that day. Okay? And it is also the time or day the deed take effect when it delivered to the recipient. And in this Hong Kong case, Hong Kong Building and Loan Agency Limited, the court, Justice Sakwani, held that there was a rebuttable presumption that the day appeared on the deed was the day of delivery. So this is what the court also recognized. Rebuttable presumption. That means if you have evidence to prove this is not so, you can always do that. Otherwise, the court will take the date appear on the deed as the day of delivery. Now, there are two reasons, at least, to insert the correct date. First of all, if you insert an incorrect date, it is professional misconduct. And, well, it is not in a fancy, some kind of fanciful thought. In fact, a solicitor has been disciplined because he inserted the wrong day in an assignment, because he forgot to take this document to stamp. If you are late for stamping, then you will pay a penalty. Therefore, the solicitor changed the day to a later day so as to avoid the penalty of stamping. And the day of assignment may have also important legal effect, in determining priority. Remember, if you register a document within 1 month of the day, then it will be deemed to be registered on the date of the document. Therefore, it is also important to insert the correct date. And in this particular Hong Kong case, it is shown that the date is also important for certain kind of sale and purchase. Here, we are talking about a property purchased from the housing authority, and then, the guy sell the property to third parties later on. Now, under the law, you must get the consent of the housing authority before you can assign the property to any third party. Now, the day of assignment in that case was 14th of July 1997. But the date of the permission of housing authority for the party to sell was date 15th. So it would mean that before this day, the vendor actually has no power to assign the property to the purchaser. So that is an empty title. The Court of Appeal held that, in the absence of sufficient evidence to rebut this presumption, the date of 14th July was treated as the date of delivery. So the purchaser was entitled to refuse to accept the vendor's title, because the title must be empty. The third part of an assignment is the parties to the assignment. Now, and it is as I said, particularly if the sale and purchase involve any third-party confirmor, all the parties involved in this transaction must be named in the assignment. So normal circumstances, the only parties are vendor, purchaser, but when you have confirmor and sometimes nominators, then parties could be more. And if you have a nominator would be something like this, similar three party. Vendor sell it to the nominator. This nominator then ask the vendor to make an assignment to the real purchaser. Of course, it could be the nominator who actually purchased this property to P, but in the assignment there is only the assignment from V to P, and this is only the nominator. This is the nominee. So there may be three parties in an assignment. Now, if it is a gift, for example, you purchase a property for your loved one, for your son, for your daughter, for your spouse, then, amazingly, the law only requires the donor be the necessary party. And now, just give you a further explanation of confirmor sale. You have the vendors sell it to the confirmor and the confirmor to the ultimate purchaser. And because he also acquire an equitable interest when he entered into the sale and purchase agreement with the vendor. So in order to ensure that all the rights and interests from the vendor will eventually assign to the ultimate purchaser, this confirmor will appear in the assignment to say, I confirm this particular assignment. Therefore, to indicate that he give up any possible equitable interest he possesses. In case of nomination, vendor give it to nominator, and nominator, ask the vendor to assign the property to the nominee. So normally the purchaser will insert a clause in the formal agreement that the vendor agrees to sell to the purchaser's nominee, and in that case, when the assignment was made, the vendor would then directly assign property to the nominee. And again, in order, you should learn that if you purchase property in another person's name, it is a resulting trust situation. So if you disclose your name in the assignment saying that I'm the nominator, then the presumption of resulting trust would be rebutted. Okay, so people would not be afraid that the nominee is only holding the legal estate, but not as well the equitable interest. And parties must be identified by their full names, including any alias. That means their second name, third name. If they have Chinese character, Hong Kong people, they have Chinese name, they should also put down the Chinese character. And again, this should not be happen. You should not spell wrongly certain word, but it did happen in the real world. In this case, Sun Luck International Development Limited, Sun Luck agrees to sell a flat to a purchaser, and the purchaser looked at the title document and find out that the assignment by the previous owner to Sun Luck, there were two wrong characters as to the Chinese name of Sun Luck. Therefore, they said, Sun Luck did not have a good title. The assignment was defective. Well, this case was, of course, Sun Luck said, no problem. There should not be any problem because their company registration number was also included. Business registration number was also included in the assignment. And the court agreed with Sun Luck. the title was not defective because the business registration number was correctly inserted. And on top of that, there was no company registered in the Chinese name of Sun Luck with the two wrong Chinese characters. Therefore, it must be a clerical error. Similarly, in order to avoid any possible mistake, you are encouraged to insert the ID number, together with the Chinese character of a Hong Kong people, Hong Kong person. In case there is any wrong with the spelling of Chinese character, the ID number could be used to identify the particular party. Now, if all the three are wrong, then it is your problem. Then I would say the assignment would be defective if that is the case. And many assignments include what we call a recital. That is something introductory paragraph. And the recital begins with, again, whereas, all in capital letters, and provide information of the vendor and the purchaser. But this is not really important. Therefore, it's not really required. It's not an operative part of the deed. Now, there are two kinds of recital. One is called narrative, and the other called introductory. Narrative recital gives the history of the title, why the present assigner has become entitled to assign the property. Now, for example, if the assigner is a personal representative, if he is the assigner, then of course we don't have to explain why this guy would be executing the assignment. But if the owner is actually the pass away, and his property was dealt with by the executor. Now then, this executor would explain why he got this power to transfer, and then he would, in the recital, explain, there was a will, and the testator appointed him as the personal representative or executor, and etc. And now because of that, he got this power to assign. An introductory recital usually written after the narrative recital, and they usually talk about the facts in relation to the title of the property. Now, why it is important to know or learn about this recital? Because the recital may be useful for answering requisition sometimes. Because under section 13, subsection 3 of CPO, a recital of a pre-intermediate root document. Now, I will explain what is pre-intermediate root later. It's presumed to be correct unless the contrary is proved. And section 13, subsection 4 even say, if that recital was made more than 15 years before the present transaction, it is presumed to be true unless the contrary is proved. So one is about facts, and the other is about the title. The assignment, there is part called a testatum. You will see in an assignment a phrase like this. Now this deed witness, spelled like this. And this is called a testatum. Again, it is only a matter of practice that they use this phrase, and then witness what. That means this deed actually prove the transfer of a title. It just serves as the introductory phrase of the operative part of the assignment. Now, there is one particular important clause in the assignment. It's called consideration clause. Always start with this: in consideration of the sum of certain amount of money paid by the purchaser to the vendor, then the vendor transfer this property to the purchaser, something like that. Now, you should remember, if a contract was executed in a deed, then it's not necessary to have consideration in order to enforce that contract. But it is always a good practice to insert the correct amount of consideration in the assignment. Now, if it is a gift, what is the normal consideration? Well, interesting. It is love and affection. In consideration of love and affection, Mr. Wong assigned the property to his wife, Mrs. Wong. This is the usual word used in the Hong Kong assignment. Now, another reason to insert a accurate amount of consideration is that the assignment needed to be stamped. Under the stamp duty ordinance, you have to stamp the document, and it was according to the consideration how much stamp duty the party has to pay. Of course, if it is a sale and purchase situation, normally you already have to pay the stamp at the stage of formal agreement. But in theory, Section 11 of Stamp Duty Ordinance also applies to an assignment, particularly if it is a assignment of gift, then you would not have any formal agreement. Then the assignment itself would have to be stamped. And then, receipt clause, that means the vendor have, in this assignment, acknowledge that he has received the money, and there are basically two functions for the receipt clause. Under Section 18, subsection 1, the clause serves as the sufficient evidence that the burden of payment of consideration has been discharged. Once you have the receipt clause, then it means vendor has already obtained the payment from the purchaser. And under Section 18, subsection 2, receipt clause is the evidence that solicitor producing that assignment is deemed to be authorized to receive the consideration. So again, this is important because in many cases we are making payment to the solicitor. That would be safer than give the money directly to the vendor. And there is a what we call covenants for a title. Now, it is something like this. Vendor as beneficial owner or legal chargee, personal representative, sign the title to you. And the purpose of this clause is to ensure that the assignee obtain the title he intends to get. And now, under Section 35, it is not necessary to insert detailed covenants as long as you use certain trigger words. For example, if it is a sale and purchase, we just say vendor assigned as beneficial owner. Then once you have these words, this is called trigger words, following covenants would be implied. Government list is good and valid. Premium of the land has been paid. Government rent has been paid up to date. Government list has been observed or performed up to the day of assignment. Vendor has good title to assign. Land may be quietly entered during the residue of the term of the government list. Covenant or further assurance, etc. Only put those trigger words, you will have all these terms being implied. Now, then what are the words for grant? How you grant the right? If you say the vendor, we say the vendor assigns the right, etc. to you. If it is confirmed, then we will say the confirmer confirms and assign. if it is the borrower executing a charge, we will say the borrower charges the property to the bank. And about the property, in the assignment, it must include all property to be assigned. If it is a, assignment of certain undivided share in a multi-story building with exclusive possession of certain flat or unit or car park, all this has to be clearly described in the assignment, so that there will be any doubt remain. And in the assignment, property is fully described. It includes the address. But in fact, it is not required by law now, even though in practice the lawyer will still give the full address. Lot number, section, undivided share. This is relevant to the property. You must have that. And if the property is a multi-story building, number of undivided shares should also be stated. And if there is any exception reservation by the government, basically it is the government said, well, I assign you this list, but there are some exception. You cannot enjoy certain part of the land. Maybe that could happen. And the government also reserve certain right on the land, etc. And if there is any easement, any other tenant rights, they should also be scheduled. Stamp duty, consideration. Now, stamp duty is paid. Now, the technical term is ad valorem. That means according to the value of the property. And it is particularly important for commercial or industrial property and assignment by way of gift, because in the gift situation, the assignment is stamped, but in a normal sale and purchase, then the formal agreement is already stamped. Now, what is required in practice is that the party, the assigner, must certify that this particular assignment does not form part of a larger transaction or a series of transactions in which the aggregate value exceeds the amount stated in Head 1A of the stamp duty. Now, this is where you find the stamp duty you have to pay. Now, it is a scale fee. Now, for a certain amount of money, you pay this amount of stamp duty. So, in order to avoid parties to, make the big transaction, cut it into small parts. For example, actually the sale is an entire multi-story building. The value must be very high, and the stamp duty is also high. So you just say, I assign for number, say 10 story, assign for number 1 to 3 in one assignment, and then 4 to 6 another, and then 7 to 10 yet another transaction, so that to cut down the value of the property. So you have to spell out or make this declaration. This assignment does not form part of a larger transaction or series transaction. Now, this is the good old days. Before 23rd February 2013, a fixed duty of 100 was payable, where the consideration is below 2 million. Existing duty is 1.5% of the value of the property. Now, if the property is 4 million, for example, you have to pay the 4 million times 1.5%. But if you cut it into 2 transactions, each of it is just 2 million, so it was only 100. So that you can save a huge sum of money. Therefore, government requires you to make that declaration in the assignment. It does not form a series of transactions. And ultimately, the execution, attestation, and interpretation. So at the end of the assignment, you would have sign, seal, and deliver by certain person. This is called execution. Attestation, there must be someone to witness your signing of this document, and usually it is solicitor representing the party who would attest the execution. And interpretation would only be required when the document is in English, but the assigner does not read English. Then someone has to interpret the assignment to him so that he, when he signs this property, he knows what he is doing. And in practice, the attesting witnesses and the interpreters will also put down their names and the Hong Kong ID number in the assignment for identification. So basically, this is the process for conveyancing. I've rushed a little bit because all these are factual things. There's not much law to know except for completion. Remember, time is for action. Two things. One is you have to arrive there on time. Number two, Section 71, subsection 1B does not apply. Even if the days for completion is on public holiday, you have to attend the the vendor solicitor's firm to complete. You cannot rely on Section 71, subsection 1B to delay it to the following working day. And the midnight rule. These are more important exam topics for this particular lecture. But for the next lecture, it is more important. It is about title. I'm sorry, for exam purpose. And because we need more time to deal with this lecture, so I rushed a little bit for the previous one. Now, we have just seen the typical way of conveyancing in Hong Kong and also examine the most important documents. And now we are focusing on the role of solicitor and sometimes involving also barrister in this process, particularly the duty to show and give good title. This is the most important and most difficult part for lawyers. Of course, we already know that in Hong Kong, the preliminary agreement was executed in the estate agency office so that there is already a binding sale and purchase agreement before parties instruct any lawyers to represent them. For example, the price, the method of payment, day of completion, all these would have been agreed before the solicitor is instructed. Now, when those solicitor, we just learned that, has the duty to draft the formal sale and purchase agreement based upon the preliminary agreement, and the purchaser solicitor then have the duty to approve this formal sale and purchase agreement. Now, except that there are special circumstances, as I said a little bit earlier, when those solicitor will only insert the most common clauses typically found in a formal sale and purchase agreement in Hong Kong, and they are generally accepted by the purchaser solicitor. And in my own practice, there was one particular case in which parties could not agree to execute a formal agreement just because the purchaser insists on to have a formal completion. that formal commission actually give you more protection because everything could be done at the same time. But then, not just solicitor themselves, but even the purchaser find it too complicated. Therefore, in that case, the vendor disagree to have this clause inserted in the formal sale and purchase agreement, and they ultimately could not reach an agreement on the formal sale and purchase agreement, and they had to rely on the preliminary agreement. And in one of my experiences that, again, it is the tech case, challenging the title case, in which when purchaser insists to have formal completion to make it difficult for the vendor to complete. And the vendor then, as to retaliate, he said, okay, I will arrange formal completion, but I will not accept any check. So you will have to give me cash. So at the day of completion, the purchaser instruct some security guard, 2 security guard, 1 carry with a gun and carry, boxes of cashes, and go to the vendor solicitor office, and then there they have to count the money and then ultimately exchange everything. That was one of the most interesting experience I had. Now, once the formal agreement is executed, the most onerous duty of the purchaser solicitor begins. Examination of the title document to ensure the purchaser is buying a good title, of course subject to express agreement. And why it is onerous? Because the purchaser solicitor will be liable for professional negligence if the title of the property he approves turns out to be a bad title. Again, my experience is that some solicitor has to purchase the property of his formal client, because when the formal client tries to sell the property to a purchaser, the purchaser solicitor discover or detect some fatal defect in the title, and they just cancel the sale and purchase agreement. So the formal client turn back to the solicitor. Why did you approve this title for me last time? And then, of course, I said, oh, I overlooked it. So pay me the compensation. The only compensation the formal client accept is you purchase the property for me. So the lesson to learn here is when you see the owner of a property is a solicitor, and he's selling the property to you, you have to instruct really good lawyer to look carefully, just in case this solicitor purchased the property from his formal client. So, good title is important, and we are trying to learn this concept of good title. Unfortunately, this concept is a little bit abstract. Now, of course, in common legal expression, subject to any express provision in the agreement, the vendor has a duty to show and give good title to the purchaser. And, show good title, 2 stages. We already mentioned that. First one is to produce the documents. So if a vendor already mortgage his property or execute a legal charge of a property to the bank, he would not have the title deeds. And what would be done is that the solicitor representing the vendor would write to the solicitor of the bank and said, well, please release the title document to us because we have to let the purchaser to examine, and we undertake to give you all this title on demand. Likewise, when this solicitor passed the title documents to the solicitor of the purchaser, they would say, wow, these documents are now passed on to you for inspection upon your undertaking to return all these title documents to me on demand. So they have to protect their interests when the title document was actually kept or retained by a third party. Now, so the first stage, vendor gives you, pass on to you the title documents. But since the current system of land registration does not guarantee good title or guaranteed title, so the vendor's duty is only to pass on to you the documents, and the purchaser has to examine the documents and find whether there's any problem, any what we call encumbrances. Later on we'll explain what are encumbrances. Ensure that the vendor's title is good. Now, this is something that you have to learn, because this question, I more or less can guarantee that it would appear in your exam in one way or another. Section 13. Now, Section 13 is the provision, statutory provision for duty to show good title, unless the contrary intention is expressed. A purchaser of land shall be entitled to require from the vendor as proof of title to that land only production of the government list relating to the land sold. Well, if it is really only the government list, it would be much straightforward, but you have the word "and." Now, so it means when the vendor tries to discharge his duty of showing good title, he has to produce, first of all, the government list to the purchaser. Okay? And where the grant of the government list was less than 15 years before the contract of sale, that is the present contract of sale, the present transaction, extending for the period since that grant, or in another case, extending not less than 15 years before the contract of sale of that land, commencing with an assignment, a mortgage by assignment, or a legal charge, each dealing with the whole estate of the interest in the land. Now, this is the word highlight, is the concept of intermediate root of title. Now, what does this two section actually means? Now, you have to produce, vendor has to produce, number one, government list, and then the title document described in this proof of title to that land under A. Now, there are two possibilities. The first possibility is, so you have the government list. Say, for example, the government list was granted in 2001. And what is our year, the time for this year, 2021, right? Now, if, say for example, we are talking about there was a transaction in 2010. Now, let's ride on a time machine and go back to 2010 first. If there is a purchaser in 2010 interested to purchase the property, then it would be the application of Roman letter 1. The grant of government list was less than 15 years before the contract. The contract is here, 2010. And it is less than 15 years from the grant of the government list. Then the documents required to prove title would be from 2001 to 2010. All transactions, including assignment, contract of sale and purchase, legal charge, and other legal interest, easement, etc. You have to produce all the title document in relation to those interests. Okay, there may be an assignment in 2002, there was a grant of easement in 2006, etc. You have to produce all of the documents, title document, in relation to those legal interests. Okay, so this is a little bit straightforward. If the current transaction is less than 15 years from the year of the government list, anything happen in between, any transaction, you have to produce the title documents for those transactions for the purchaser to inspect, to see whether the transactions are in order or not. Okay, this is Roman letter 1. What about in 2021? So it is more than 15 years. Okay, in any other case, extending not less than 15, we have to identify and what we call the intermediate root of title. And how to identify this intermediate root of title? We have to use the current time as the point of departure, point of reference, and go back 15 years. And when we go back 15 years, we will look for assignment, mortgage by assignment, or legal charge. Only these three legal interests: assignment, mortgage by assignment, or legal charge. Of course, nowadays we don't have mortgage by assignment anymore. So basically, only assignment and legal charge. And this assignment and legal charge deal with the whole estate. That is 100% interest of the property, but not just 30%, 50%, 80%. For example, if the property is held by more than one owner under tenants in common, each tenant in common is entitled to deal with his or her own share of the interest of the property, right? So he, say for example, if this property is owned by two persons, a 60-40% tenants in common situation. In theory, the one holding 60% can, execute a legal charge in relation to that 60% without joining the other party, right? Now, if you have this kind of transaction, not dealing with the 100%, that could not be an intermediate route. You must have a transaction in relation to assignment or legal charge that deal with the entire estate or whole estate. That means 100% interest of the property. And you use that as the intermediate root of title. So, for example, in this particular example, say not less than 15 years. So maybe we'll pull the time a little bit earlier to make it easier to. Okay, say 1997. The current contract is in 2021, then there are so many different transactions within this period. So you are looking for an assignment or legal charge at least 15 years from 2021. So it would be 2006. So you must find some transaction, assignment or legal charge at least 2006, which deal with the whole estate, 100% of the property. Now, sometimes it may not be 2006 because there was no transaction in that year. It may as early as 2000 because that was the only transaction. But this will become the so-called the intermediate root of title. Say, for example, in 2006, there was an assignment from the then owner to the purchaser. And we can use that one as the intermediate root of title. At least 15 years. It could be earlier, depends on the situation of that property. Now, once you have identified this intermediate root of title, then you have to produce from any transaction between the intermediate root of title and the current sale and purchase agreement. Now, the transaction within this period is called the chain of title. And you have to produce all title documents in relation to the transaction within this chain of title, no matter it deals with 100% or even only 1%. But for the intermediate root, it must be the whole estate, 100%. Once you identify this is the chain of title, these are the documents that you have to produce for the examination of the purchaser. And it would also mean that if there is any transaction between 1997 to 2006, no matter how many, no matter what estate they are dealing with, you don't have to produce any document at all in relation to those transactions. Your duty is only confined to the transaction between the intermediate root of title and the current sale and purchase. Okay? So this is a little bit tricky. If the government list is executed less than 15 years from the current sale and purchase, then straightforward. All transactions that affect the interest of this land, you have to produce the documents. But Roman letter number 2 is talking about when the government list was executed more than 15 years from today, then you have to identify the intermediate root of title. The intermediate root of title must be at least 15 years from today's transaction and must be an assignment or legal charge. And it must be dealing with 100% interest of the property. Okay? So, government list plus the chain of title, and this is production of any document refer to the assignment, mortgage, or charge mentioned in paragraph 8, that is those documents creating or disposing of an interest power obligation which is not shown to have ceased or expired. particularly if any transaction which still affect the interest of the current land. But even though the word said which is not shown to have ceased or expired, even if it is expired, you still have to produce the document. Because if you do not produce, the purchaser would ask you for that. Because the purchaser would also conduct a land search to look at what kind of transaction has taken place. If the transaction is within the chain of title, they would need to have a look to ensure that this has been seized or expired. Right? So even though the word said which is not shown to have ceased or expired, in fact, no matter it has been seized or expired, you still have to produce them. So in effect, you have to produce the chain of title from the current transaction to the intermediate chain of title or to the government list. Depends on when that government list was executed. Now, C, this is also the documents that you must produce. Any power of attorney which is executed less than 15 years before the contract of sale. Okay, that means from the current transaction, look back 15 years. Look at the transactions within these 15 years and see whether there is any transaction in which the execution of the document involve the use of power of attorney. Power of attorney means that you ask someone to execute the document on behalf of you. And you must have a formal document to confer that power on the person. So there are mainly two kinds of power of attorney. One is called general power of attorney. That means you will give all your power to that person to do anything on behalf of you. But there are some specific power of attorney in which the person would just confer a limited right on that person. Say, for example, I just confer him the power of attorney for executing this particular assignment. But no matter it is general or specific power of attorney, if there is any document executed by a person under the power of attorney, you have to produce that document, that power of attorney for the purchaser to inspect, to ensure that the execution of the relevant document is within the power of attorney. And don't have to go back to history, only the power document executed by power of attorney less than 15 years from the current sale and purchase. Okay, so in exam, the examiner always asks you, when a vendor is required to give and show good title, what kind of documents he has to produce? And you have to go to this particular section, section 31, and say, oh, these are the things. And then go back to our subsection 1 about the government list. What if the property or the list was granted after 1st of July 1974? What documents that you have to show to stand for the government list? Because under section 14, remember CPO, 14 CPO, government no longer issue the physical copy of government list. But once all the conditions of sale are being satisfied, the government list is deemed to be issued. So in those cases, the documents that you have to produce is the certificate of compliance by the building authority or lands department, because that would be the evidential, documentary evidence to prove that Sections 14 has taken into effect. The government list is deemed to be issued. Okay? Now this section we are still talking about show good title, right? Or prove good title. At this stage, it shall be sufficient to produce a copy. So it's not required to give the original at this stage. But this copy must be a certified copy, either certified by a public officer or a solicitor, or if the copy dated before 1st of November 1984, the copy could be an attested copy. Because, before this day, in fact, there was a lack of solicitors in Hong Kong in the old days. So you cannot always have enough solicitors to certify some copies. So in those days, solicitors' clerks were empowered to certify. Of course, they do not use the word certify, they use the word attest, to attest a copy as true copy. But solicitor is more reliable, clerks are less reliable, so we need two solicitors clerk to attest that the copy is a true copy. But that only applies to documents executed before this date. Any document executed after this date must be certified by a public officer or a solicitor. Okay? To be true copy. So, to sum up, the law to me is very straightforward. I read the lines, I know what they're talking about, but for your benefit, I just sum up what is actually meant under that section. Unless there is an expressed agreement to the contrary, the vendor normally has a duty to produce all relevant title documents extending back at least 15 years, because the intermediate proof of title requires 15 years, so at least 15 years from date of the current contract of sale and purchase. And it means the vendor has to produce the government list, if exists. If not, the certificate of compliance and the intermediate root of title. What is the intermediate root of title? It was the assignment or charge of 100% interest of the property extends at least 15 years back. And all title documents relating to the transaction affecting any percentage of the interest of the property from the intermediate root up to the present sale and purchase agreement. And this also known as chain of title. In exam, always remember to use this term, chain of title. And any power of attorney, if there is any document executed by an attorney within 15 years. So this is the summing up of all those sections under section 13, all those subsections. Now, immediate effect is that under this section 13 subsection 1, the vendor has no duty to show good title between government list and the intermediate title. So don't ask me any question in relation to the transaction between the government list and the intermediate root of title, because section 13 does not require me to do that. And this is endorsed by the court in the Dawson Properties Limited case. Now in that case, the government list was dated 1843 and the intermediate route was an assignment went all the way back to 1931, because no transaction after So you have to rely on an assignment in 1931. Now, the grantee of the government list, at the very beginning, the grantee was Sen Tak Fan. And the assignor in the intermediate title was a Mr. Feng Wo Yin. The purchaser then raised a requisition. He said, "Can you show me how the title of this property evolved from Sin Tak Fan to Feng Wo Yin?" So in effect, he's asking the title problem between the government list and the intermediate title. And of course, the vendor said, "No, I am not required to give you any answer because under Section 13, I do not have that duty." And this argument was accepted by the court. And the court said that Section 13 did not require the vendor to prove his title between the government list and the intermediate title. And it is therefore not necessary to show how title has evolved from Sin to Feng. Now, this particular section, Section 13, in relation to the document you have to produce and also your duty, is not extended to any transaction between the government list and intermediate recurrent exam question. Therefore, I spent this long time to explain it to you. But for those, 3 stages, I just rush through because this is really important, and also in practice, they are also important. Okay, so I'll see you on Wednesday.